Good morning. First of all, I'm State Representative Carolyn Hughley, and I want to thank each of you all for being here. I want to thank our committee members who are here. We have Representative Harbin lost his aunt, so he's not going to be with us today. And Representative Mayo will join us shortly. I'd like to thank Representative Allison and Representative Pack for their presence today. Our study committee is on compensating wrongfully convicted persons. What we'd like to do today is go over what our current status is, what we're doing here in Georgia, and then we will hear from others who have been involved in our process. At the end, we're going to talk about our other dates. We don't have, we're going to try and do our thing in 3 meetings, because normally study committees do 3 meetings. Our resolution doesn't speak to that, but we're going to try and conform to the 3-meeting standard, if that's okay with you guys. All right. Well, would either of you like to say anything before we get started? Are we ready? Yes? No? We're good. Okay. I want you to know that I became concerned about how we compensate those who are wrongfully convicted by having the unfortunate pleasure of doing 2 of these resolutions through our General Assembly. And as we go through our process, it is confusing in that there is no standard in terms of how we measure what to do for 1 year of conviction, or 20 years of conviction, or 12 years of conviction for somebody who have been wrongfully incarcerated. And it's really based on who's in the General Assembly at the time and how that particular body feels about the subject. And so we have asked for the study committee for us to come up with a standard that we can all agree upon, and so that we can treat everybody the same. If you look at what we've done for wrongfully convicted persons, the numbers vary, the terms of the compensation resolutions vary, and that kind of thing. And so what we're aiming for is to set a standard and stay with the standard, so it won't matter who happens to sit in the legislature. This is what our standard would be, and everybody will be treated accordingly. With that, I'm going to call on Jill Travis, who is with the Office of Legislative Counsel, and she's going to go over officially what our process is supposed to be. What's your number? Okay.
Thank you, Representative Hughley. There's in your folders is a sheet of paper that says compensation resolution process, and that's just kind of a bullet point outline of what the process is. And I just wanted to speak to you about how it works generally. And you don't need to read along, but that's just for your reference. So the way it would work, and let's presume somebody today, right now, had been released from custody in a situation in which there was a wrongful, I don't know if wrongful conviction is the right terminology, but they spent time in prison for an offense that subsequently they were exonerated of, or mostly exonerated of, and that's, I'm sure Amy Maxwell will be better able to describe the circumstances that leads to it. But in any event, that person comes out of jail today, and they want to make a claim against the state. They would have to, before November 15th of this year, file a claim with the Claims Advisory Board. And the Claims Advisory Board is a division within the Secretary of State's office. And if you just Google Claims Advisory Board Georgia, you'll come up with a website, and it takes you to their page, and it really walks you through very specifically how to file a claim if it's over $5,000. And there's a form that the person would have to fill out. They, of course, could do that with counsel or without counsel. They could have, at this point, contacted a General Assembly member. But in any event, the first trigger deadline is the information has to be submitted on a claim form before November 15th of the year preceding the session in which a compensation resolution would be introduced. The board has the authority to investigate the claim and make recommendations on the claim. They can hold a hearing on the claim. The person making the claim can be present. A General Assembly member can be present. There's pretty wide latitude on how they can hold their hearings. But in any event, let's go forward with what the legislative process would be. And that is, first of all, of course, the General Assembly member would have to introduce it. It would have to be a House member. These have to originate in the House. And that compensation resolution would have to be introduced within the first 10 days of the session. The compensation resolution itself is much like a personal injury complaint. It would set forth the facts of the circumstances leading to the conviction, the types of losses suffered, and the amount of compensation sought. The law requires that these compensation resolutions be assigned to the House Appropriations Committee. Once it's assigned, and once it's filed and assigned to the House Appropriations Committee, a copy of the resolution is sent to the Claims Advisory Board. And I would say that that's sort of like a check and balance, making sure that the person actually had filed the right paperwork in order to go forward with the House resolution. And from there, it's just like any other bill or any other resolution, in that it's in the body of the legislature to determine the exact wording of the resolution, how much the dollar figure is going to be, whether there's going to be any contingencies on the type of compensation that is paid. And I would like to direct your attention to the sheet of paper that says Compensation Resolutions 1994 to 2014. And what I did is I just went back and looked at the compensation resolutions for individuals over the past 20 years. And I mean, this is really my shorthand. So it's in order to really determine the specifics of each of these resolutions, the information is there if you care to look for it. But beginning in the year 2000, Calvin Johnson was the first person to be compensated. He received $500,000 from the Department of Corrections, and it was a lump sum payment. And you can see that he spent 16 years and 3 months in jail, in prison. And then in 2005, Clarence Harrison, he received $1 million in an annuity over 20 years with an initial sum of $100,000. He spent almost 18 years in prison. Then Robert Clark in 2007 with 2 annuities, and you can see that one continued after his death. And then in 2008, Pete Williams with an annuity over 20 years with an initial lump sum. That one was not taxable, and the legislature added a contingency that it would be forfeited if he was convicted of a felony. In 2009, John Jerome White, again an annuity, and more contingencies were put on that. This one ceased at death, or if there was a felony conviction, or if he had a positive drug screen requiring him to be screened for drugs unannounced. And it also added a contingency of it wouldn't continue if he was unemployed or not seeking employment or not volunteering, so requiring some working on his end. And then the last one, or working at working. And then the last one was for Lathan Word in 2013, again, over 20 years, an annuity. So, and having to do with attorney's fees. But the main thrust of this is obviously there is a lot of variety in what the legislature has determined to do over the last 20 years with respect to these situations. And there are some states that do it differently than and have a process for it, but this is the process that's currently in place. There is a 2-year statute of limitations for filing this type of claim. And I think that explains the current process and where the legislature's been on this for the last 20 years. I'm happy to answer any questions you might have. And I did print out, if anybody, I just made one copy, or I've got 2 copies actually, of the Claims Advisory Board forms, if anybody wants to take a look at that.
Gentlemen, are there any questions? Mr. Mayo, is that you, number 25?
Madam Chair, you mentioned one of the conditions being the person has to be working at working, and everything I've learned about individuals who have been released who may have some type of background in the judicial system, it's difficult to find work. And it just sounds like there are a lot of conditions being put on these individuals. But how would we describe or define working at working?
Well, and again, this was only in one of the resolutions over the last 20 years, but the wording in the resolution said, no payment shall be made during any period during which Mr. White is not employed, is self-employed, performing voluntary work for a charitable organization, or seeking employment. The Department of Administrative Services was involved in administering this, and this is also another condition that was on this particular House resolution, required that Mr. White and DOAS enter into a formal agreement. And so I can only speculate that there might have been some language within that formal agreement that spoke to that matter.
Is it not true that the state is in the wrong for convicting these people? Or are they incarcerated wrongfully, and the state has some responsibility to compensate them without, unconditionally, because of an error made on our part?
I would say that is within the wisdom of the legislature to make that determination. And I would point out that Mr. White did spend 28 years in prison. But the circumstances and the nature of the payment to an individual, that's up to the legislature to determine what's fair and what conditions to put on it. There is nothing in the law currently that provides any parameters to this. I will point out that the State Claims Advisory Board has the ability to make a recommendation to the legislature in terms of compensation, but that's only advisory.
If I can jump in on that one, because that was one of the ones that I was involved in. What happened was that we were trying to get the resolution through, and when all of those conditions were put on by the Senate, and they were going to kill the resolution unless we accepted all of these conditions that had never been on any other resolution before. And we have somebody here from DOAS, and I don't know exactly how they're monitoring that, but we're putting an additional burden on the department to keep up with this person when their general function would be to administer the annuity. So we're making them be his PO, probation officer, in essence, with that particular resolution. And that is one of the reasons we're here, because there is no consistency. Number 22.
Thank you, Madam Chair. Quick question. Setting aside for right now what constitutes a wrongful conviction, and looking at the chart, I had some questions about if the person applies, does he or she waive any legal rights to sue? Meaning, is this kind of like workers' comp when you opt in and then you kind of get rid of all the, you waive all your other legal rights in terms of seeking redress for false imprisonment or anything like that? How does that work?
To the best of my knowledge, this would be the way that the matter is resolved. I mean, you've got the State Tort Claims Act, and I took a look at that, but I don't think that's written in a way in which somebody that was wrongfully convicted could qualify for compensation. don't know, because there's an exclusion for prosecutorial conduct and because of the tort that would be required. I'm not sure what the tort would be, so I don't think you could sue under that. I do believe this would be the only manner of recovery.
Okay. Two comments just kind of that jumped out at me, and something that I guess the committee would throw out there to consider. One is probably these cases are very tough to bring, to exonerate somebody, so we probably want to consider an attorney's fees provision to award or encourage lawyers to actually take these cases. And I think the Innocent Project people are here, but I think they're shorthanded on a lot of stuff. You're probably overwhelmed these days because of the DNA cases, and you see a lot of people being exonerated because of DNA. And I know that they're overwhelmed with that. The second thing is, I wonder if we could take a little bit more formalistic view of kind of figuring out how much per day or per year or per month of incarceration we should compensate somebody based on what we thought that their earning potential was, plus kind of the pain and suffering and the hardship that they have suffered past and going forward, and come up with something that we could kind of work with in terms of framework. Otherwise, I mean, I agree that the just by looking at just Georgia, we're kind of all over the board in terms of years. And it looks like Mr. Johnson in 2000, the amount that he got is completely, overshadowed by someone who spent less time in prison. And so, those two things that kind of jump out at me in terms of something that I would like our committee to consider. Thank you.
I did want to just mention one other thing is that in 2014, Representative Hughley introduced House Bill 988, which would have been a process that could have been used to more standardize this situation, as well as Representative Benfield in 2005 introduced a resolution, and that might be the direction that the committee might want to consider. I just wanted to mention that those were out there.
Let me just mention that I did introduce that resolution, but after I talked to our budget chair, I asked him, would it be better if we had a study committee where we can kind of sit down when we're not in the midst of session to really figure out what the best thing to do, because I think that's the most important thing, is that we have a standard that we can agree upon and that we treat everybody the same. And so that's why we're here with the study committee. All right, Mr. Allison.
Thank you, Ms. Travis. I was actually going to say almost what Representative Pack just said. When one of these, I guess, claims is filed, do they make an ask for an amount of money? So we give them no guidelines what to ask for, because according to this, I just did a little rapid math on my phone, Mr. Harrison in 2005 got $1 million for 17 years, which came out to be somewhere in the vicinity of $50,000 per year. And Mr. White in 2009, who served 28 years, got $17,000 per year. So there seems to be no set response. I guess just like a civil action lawsuit, they ask for what they ask for, and then the General Assembly, through its wisdom, is who negotiates the settlement. Is that kind of what it is?
Mm-hmm. Yes, that's correct.
And the only thing that concerned me, to follow up on Mr. Mayo's question, I guess we can ask DOAS when they get here. I'm trying to figure out, I guess if we can do it by agreement, how do we regulate a drug screen on someone for a civil action? How often is it done? Who pays for it? Do we know any of that, or is that something best for DOAS, I guess?
I have no answer to that.
I'll follow up. Thank you.
We will let you ask that when we hear from DOAS. But in terms of how we come up with a dollar amount, from a legislative perspective, I'm going to tell you what I had to do in 2013. And we have a great appropriations chair, and I went to him and I said, we have this compensation resolution, and he said, well, how are we going to come up with the amount? And I said, I don't know. We have somebody who was incarcerated right out of high school, so they never had a chance to determine what their income would have been or anything like that. And the only thing we had to go on was he was incarcerated a few days before he would have gone to the Marines. And so what we did was we used the pay schedules for a Marine somebody who would have been in the Marines, what they would have normally gotten. And that was just an agreement between the chairman and myself, but there was no guidance for that. And there's no, and then the other thing is we have to figure out what will the legislature entertain. And that depends on who's in the legislature at that time. So that's why we have all of this inconsistency, because a lot of it depends on who the appropriations chair is. A lot of it depends on what the feeling of people in the General Assembly are about this whole notion of wrongfully incarcerated persons. And so that's why it's difficult. And you're absolutely right. We do need some kind of standard to go by so that our personal feelings won't get caught up in that. Any other questions for Ms. Travis? Number 25.
Just a comment. It's not a question for Ms. Travis, but listening to you speak about the standard and how we determine that, one thought I had is maybe to use the median income for that time when the person is convicted. Mm-hmm. There's usually a standard in terms of where the state is and the median income.
Okay. If there are no more questions for Ms. Travis, I want to thank you. And we're going to go to Ms. Holder. She's with the House Budget and Research Office, and we talked a little bit about the budget process, but we'll see if she wants to add some more to that.
Hi. So the budget process, just to add on to what Jill said, is fairly straightforward. There's no determining on the budget office side of things on the numbers. The numbers come based on the annuities from DOAS, and we try to predict when resolutions will come into session, and then work more with the representative who has the resolution and with the chairman to get the amount in there within that year and what's going on with the budget. But once they're passed, we try to include that number based on DOAS into the budget and go forward from there. So there's not too much other than what the process that Representative Hughley has already said on the budget side of things. It comes, we try to keep updated with DOAS. That's all I got.
Any questions for her? Ms. Travis, your light is blinking. Did you?
Yeah, I don't know why.
Okay. Okay. All right. At this point, we're going to hear from DOAS, and I want y'all to know she's brand new. She's the new commissioner of DOAS, so she was not there when we did these things, but maybe she can help us shed some light on where we are with what they do.
Thank you, Madam Chair. I appreciate that qualification of my experience in this matter. I have not been involved in any of these compensation resolutions, but I do have a general understanding of the role that DOAS has played. I'm not aware that DOAS has any statutory authority or any statutory responsibility for these type resolutions, and our authority is derived directly from the resolution that is passed from the House. Mm-hmm. DOAS has not normally gotten engaged in this process or involved in this process until a resolution has been introduced, when we consult with the House Budget Office to give them estimates. For example, if the House wants to direct DOAS to purchase an annuity, we do that research and find out what the cost of an annuity is, whether it be paid yearly or monthly or over a specified period of time. So we provide those estimates, and then once the resolution is passed and the money is appropriated, DOAS does that administrative function of actually purchasing the annuity and arranging for the payment to the wrongfully convicted person. And that is the extent of DOAS's role, to my understanding.
Okay, do you have an answer to Mr. Allison's question?
DOAS has no function currently other than directing the administrative functions. I know y'all are all very familiar with our agency. We're responsible for risk management, procurement, surplus property, and among other matters. We do not have any kind of drug testing program. To the extent that the legislature wanted to direct DOS to do that, we would have to do further investigation about how to proceed.
Any other questions? Sure.
I guess my question would be this then. I understand you're new, and I appreciate that. We have a gentleman here who's been compensated from 2009, has a condition from the General Assembly that is not being executed. I really don't care if it's not. I'm just curious because...
I cannot speak to that.
Okay.
Because I do not have any experience with that particular resolution, and I'm not aware.
Is there any way that is the formal agreement between this gentleman and DOAS confidential, or is it something that this committee could take a look at to review?
I would imagine that that would be a public record, but I would have to look into that, and I have not do not have any personal knowledge of that agreement. In
Understood.
That case.
Thank you.
Anyone else? Mr. Pat?
Does your agency, well, what's your position on whether or not you would like to have the authority to administer drug testing functions?
No.
Well, I think that question wasn't asked. That's why I asked. Yeah.
I cannot speak to the official position
Right.
of the agency regarding drug testing matters. I would speak to the fact that that does not fall within our current statutory responsibilities.
Thank you so much, Ms. Sullivan. We appreciate your presence here today. We're going to hear now from Amy Maxwell, and as she comes, I want her to include in her remarks, since she's had experience working with those persons who are wrongfully convicted, bring us to how does one become a wrongfully convicted person, and then once the convictions are overturned by our courts, what is life like for that person? What do they do? How do they operate? Because I know you all work with them before, during, and after this whole process.
Would you prefer me at the podium or?
Whichever is more comfortable for you.
What's easiest for you, yeah.
Good morning. I'm Amy Maxwell. I'm the Executive Director of the Georgia Innocence Project. We are a nonprofit. We take cases here in Georgia and Alabama, and we look at cases where identity is an issue and there's DNA that can prove who committed the crimes. So all of our cases involve DNA testing. We have exonerated 5 men in Georgia. Clarence Harrison, who spent almost 18 years in prison. Robert Clark, who spent 24 years in prison. Pete Williams, who spent 21 years in prison. John White, who spent 28 years in prison. And Michael Marshall, who spent 2 years in prison, which was kind of an anomaly. You will not see Michael Marshall's name up there. He did not go through the legislature for compensation. So how do you become wrongfully convicted? Through a series of horrible luck, horrible situations. For the most part, well, I always tell people these folks didn't go to prison because there was no DNA. They went to prison because of other evidence that was used against them. In 100% of the Georgia DNA exonerations, and there were 3 before we existed, so the project in New York exonerated 3 individuals before we started. All of these individuals were put in prison through the use of eyewitness identification. And clearly, in those cases, those eyewitnesses were wrong. So it's not that you didn't have, DNA evidence, and that's why they went to prison. They had other evidence that was used against them that is flawed. So, the question of the responsibility of the state and whose fault is it, we don't really get into whose fault it is. We just find the problem and try to correct it. So what we do is we completely reinvestigate the case. We locate the DNA evidence. We litigate to have it tested. We have it tested. In all of these cases, with the exception of Michael Marshall's case, they were rape cases. So the evidence was there. Whoever's evidence was in that rape kit was the person who committed the crime. So these exonerations, once we got the DNA testing back, there wasn't a lot of litigation after that. There was, we know who the person is, let's get this person out of prison. Now, what life is like after prison, that's, I tell, now that I've done it for a while, I tell folks that's really the hardest part of their life, is trying to figure out how to rebuild their life. Because it's like, it's like Rip Van Winkle, or being dropped on another planet. They come out of prison after 20, 25, 28 years to a world that has nothing to do with their old reality. Forget cell phones. They don't know how to use cordless phones. They don't know how to pump their own gas. Just the smallest things, much less how to form, relationships and that sort of thing. So they struggle. Clarence Harrison, our first DNA exoneree, celebrates his 10th anniversary of freedom the end of this month, on August 31st. And still to this day, he will tell you that he struggles to put his life back together. It is hard to get a job. It is hard to have the skills to keep your job, because you've grown up, you had to learn how to be a prisoner. You had to learn how to survive. That was your world. Clarence called this the so-called free world. And what he did when he was in there for almost 18 years is learn how to make prison his home. He forgot about everybody. He just cut off everybody else, and he learned how to have the best life he could in prison. Well, the best life you can in prison isn't the best life you can have out here. So we still work with all of our exonerees, trying to help them figure out how to live their life. But it is impossible. And the thing about this compensation statute, and I have been a part of 3 of the pieces of legislation that have gone through, is that this happens maybe 2 years after they get exonerated. So they get out of prison with nothing, so, and fortunately they've all had family or friends or people who have taken care of them. Otherwise they'd be living in my basement. But, they need help right away. And, when you get out of prison and you've completed your sentence, you at least get a bus ticket and probably a change of clothes, and services from the Department of Corrections, which, of course, my guys aren't qualified for because they, are not convicted felons. So it's kind of a, very quick, from the time they go in to now, sort of a quick picture of their struggles. But their struggles are, individual, and every one of them have the same struggles. They have a very hard time reconnecting with their families, and they have a very hard time just in general, and of course healthcare. Healthcare in prison is what it is, and they leave prison with issues that need to be resolved, and so there's a lot going into rebuilding a life. I am kind of shocked at what we take for granted, because we've spent our lifetime building our lives. Yes, if there are any questions at this point. I'm sorry.
You have a question?
Oh, okay.
Okay.
Thanks. So I am, I'd be happy to talk in general about compensation and about the way it goes through the legislature here in Georgia, or our experience with that. And if you have any specific questions, I'm happy to come back and answer those specific questions. Like, I am going to find a copy of John's DOS agreement. That's one of my things that I will be doing soon. I didn't participate in John's compensation statute. One of the first things was that Clarence's compensation is significantly more than Calvin Johnson's compensation was. But if you'll look at that, Calvin Johnson's compensation was a $500,000 lump sum. Clarence Harrison's was an annuity. And that was one of the things when we went to the legislature that there was an agreement on, because the annuity actually saves the state money. $1 million annuity and somebody else can tell you the numbers because I don't know it, but it's probably costs $400,000 to buy $1 million 20-year annuity. So the financial outlay of the state is not $1 million. But over time, these guys get $1 million. I think the mistake we made in Clarence's case is we had a yearly annuity. I think after that we did a monthly annuity. So I'm hoping that you will help the guys out with that, because managing money is a difficult thing for all Americans. It's particularly difficult if you've never had any money. So that's that's why it jumped. That's one of the reasons it jumped so high in numbers, but not obligation of the state. Robert Clark had some very specific medical issues. That's why there are 2 compensation bills for him. And then Pete Williams, or Willie Otis Williams, kind of followed the same pattern. It is roughly $50,000 per year. And that is set, I'm not going to say it's a standard across the country. There are 30 states, 30 jurisdictions if you include the Washington, D.C., that have compensation statutes. And 50,000 has been a consistent figure. That figure was actually used during the Bush administration. Actually, Congress and President Bush endorsed $50,000 a year for wrongful conviction. Obviously, that's been years ago, so there may be an inflation issue there. As I'm talking about that, I thought, it's been quite a while ago that it was $50,000. But that seems to be kind of a standard number that we're seeing across the country.
Can you take a question now?
Sure.
I can wait till
You're going to wait? Okay.
I will tell you that probably the leader in all of this is Texas. Texas compensates their wrongfully convicted exonerees at I think it's $80,000 up front, $80,000 lump sum, and then also an $80,000 annuity over 20 years for every year they've been in prison. They also give health care, state health care. They give state education so they can go to technical schools or universities, and they give counseling services. Now, Texas is a very different situation than Georgia, I will admit, because there have been over 40 DNA exonerations out of Dallas, Texas alone. Now, obviously, when you see that kind of pattern, the state got scared. Honestly, there was an enormous lawsuit coming down the pike in that case, in those cases. I will tell you the reason there were so many is because Dallas County actually kept all their DNA. It's not that Dallas County was absolutely horrible, which makes me think if Fulton County had kept all their DNA, holy cow. But, so Dallas was Texas was looking at a huge lawsuit, because not only was Dallas doing that, but Houston had a number because they had a crime lab that was falsifying information. So there was a lot going on in Dallas. So that's why their compensation is the largest in the country. But I think that they were really, really forward thinking and correct thinking on not just looking at the number, but looking at how to help these people become productive members of our society. So there is the range. The stipulations that are on John's compensation, John White's compensation, are a little disturbing. One of the first things that I hear every time we go into the legislature is, well, what if they commit another crime? I'm like, well, another crime? They didn't commit this crime. So you shouldn't treat them like criminals. They are not criminals. They are people who have gotten through the system, however the system, they ended up in prison. It wasn't them that did the crime. They didn't do that crime. So making a person drug test doesn't make sense, because they're not criminals. They're not under the Department of Corrections where you can say, well, maybe we need to do the drug testing. And, you know, it's great to encourage them to find work, but, you know, that's not what this compensation is about. This compensation is about, for whatever reason, this person ended up in the state of Georgia's penitentiary through the state of Georgia's criminal justice system at no fault of their own. I mean, they didn't do the crime. And so that's what this compensation is about. So why compensate these folks other than the fact that it's the right thing to do is that there are potential legal consequences. This is a safety net for the state. So, and I will tell you that compensation is significantly a less of amount than litigation. When these cases get litigated, the verdicts are enormous. And, you know, I'm not saying that any of these cases would have resulted in a verdict, but that is, you know, that is an issue that the state also usually thinks about when they're looking at these cases. So that's kind of just my general.
Okay, Mr. Allison, we'll let you go first.
Thank you. I appreciate that, Madam Chairman. Ms. Maxwell, thank you for coming today, and I do appreciate what you do. 17 years practicing law, a lot of that criminal defense. I understand what you do. However, I do have a couple quick questions, if you don't mind.
Sure.
One, I want to talk to you about the compensation. To me, you had touched on it. I would think an annuity would be if whatever this committee comes up with, I would think we would have to consider making annuity payments because, as you say, some of these people getting large sums of money right after they get out of prison. If they have money issues, would you see an annuity as the best form, maybe a fraction of it up front to make sure they can get housing and transportation and all that, but the rest of it in an annuity form? Is that what you would think?
I think it's a wise fiscal decision, and I did not mention the money up front. It is important for them to have some money up front,
Right.
because it takes a lot to establish a life. But I think that monthly annuities is a good fiscal decision.
Second, having been in the legislature now for 6 years and seen several of these come through, I can tell you that some of my colleagues who struggle with these decisions have one major concern, and I think you're the best person to address it today and then subsequently. In any of these cases, because as a lot of people who don't practice law, was there ever any instance in any of these that you've worked on of prosecutorial misconduct?
No.
So all of it was just faulty witness testimony?
In all of these, no. They were all just faulty witness testimony.
And all of these have been subsequently exonerated through the use of DNA from the rape kits that were taken by the detectives? Is that what happened?
Correct.
Okay.
And I will also tell you that in 4 of our 5 exonerations, the real perpetrator was identified.
It seems to me, because I remember Mr. White's case, I was actually Mr. Mayo's, and I freshman term, I believe, is when we passed this. And I could be getting this incorrect, so forgive me. And another concern of that one, I think, which caused some problems in the Senate, did he have a prior conviction for burglary, if I remember, that he was serving a concurrent sentence?
He did have a prior conviction that he served. Part of that was a concurrent sentence, yes.
I take it, would that, if we were to look at that, if you had someone who was subsequently serving, I guess the concern about this one in 2009, when I remember, and why so many of our colleagues in the House struggled with it, was that he was, if I remember my facts could be wrong, that he was incarcerated at the time he was accused. Was he not?
Very shortly around there.
Yeah,
yes.
because my understanding was he was actually convicted while he was actually serving a burglary sentence. So a period of that time, he was actually serving another sentence.
Correct.
So in that case, if something like that were to happen in the future, how would we deal with the situation if you have 2 sentences? If you have someone serving a 5-year stint for burglary, and then while they're incarcerated, they're wrongfully accused of something else where they overlap. I know the problem with a lot of these cases, which makes them incredibly cruel, is that they're rape cases, and rapists are treated a lot different than a white-collar criminal in prison. So I understand that, but that was, from my memory, that was what was fundamentally difficult with people making that decision in 2009 was that prior conviction.
And I understand that, yeah. I mean, I think the prior conviction that you're serving, that is not enhanced by your subsequent conviction. If it was like, you had this wrongful conviction and then you got convicted of something else, that might enhance the penalty. Your wrongful conviction might enhance the penalty on the subsequent. So I can see that would be a difficult thing to negotiate as you're doing that. And I can see the argument of, if he's in prison for one crime and then subsequently gets convicted of something else, that term that he was correctly convicted, correctly, that might come out of the total number of years.
And one last question, and then I'll let these other gentlemen ask their questions. What is do we have any surrounding states? Tennessee, Alabama, Florida, South Carolina. Do any of those 4 states have these kind of resolutions that we could possibly research and find out?
Surrounding states. I know that Alabama does not. I will check that out.
Okay.
I know that we don't consider Florida one of the southern states, but they do have a compensation statute. I know that, and as does Louisiana. So I know that those states are just because I'm sorry?
And Mississippi?
Mississippi, yes, correct. Because I know their programs. But I will check the actual surrounding states.
Madam Chairman, I think that might be able to kind of use that as a guide if maybe the next time we meet, if we could see what surrounding states have them so we can kind of see how they're doing things. Thank you, Ms. Maxwell.
I did want to say one more thing about the subsequent, the 2 crimes. The other piece of that is kind of, you have to think about is parole, because he might have been able to get out parole, but all of these other things. So there are it's not cut and dry, but I can understand the issues.
Just for the record, on the John White case, the times that he was correctly convicted was not included in the number of years, even though the total number of years is on this chart. But when it went through the process, that was not included. And then also, I think this whole notion about if he could was convicted of another crime and all of that. Part of the problem with it going through the legislative process is that we all operate from our point of reference, and it makes it hard when we can't see how this could possibly happen to somebody or how somebody could actually do this. And most of us in the legislature are non-lawyers, and you all have the advantage point of being lawyers and have more experience, but the whole notion that somebody was convicted of rape that overshadows everything else as you go through that process and makes it really, really difficult. But we have that information for you already, Mr. Allison, and we're gonna send that out before our next meeting. It's a table that shows what all the states are doing. Okay, we have more questions for Ms. Allison. Number 25.
Thank you. I see we have 6 compensation resolutions in front of us we're reviewing from 2000 to present. I'm curious to know if you have any view of how many we should expect to see in the future. Do you know what's in the pipeline?
I can't answer that for sure, but I just can't imagine it's going to be more than. I don't think there's going to be a lot. It's not a floodgate. I'm trying to think of, I'm trying to do my math and figure out that's like one every 2-3 years that we've been in, 2 years that we've been in existence. So, at most, as far as where when I'm thinking about my case lists, probably about that rate. It is, as you said before, it is not easy to exonerate these folks. So when, we finish up a case that we've, tied it all together, and it takes a while. So for someone to qualify for this, it's a big hoop
right.
to jump through.
Mr. Pack. I'm sorry. Now you're on.
A couple things related to kind of the process. One is, it seems to me the disparity kind of came about because of the fact that when you go through the legislative process, people have different opinions on what condition should apply and things like that. In your experience, when you see like other states what they're doing, and I couldn't tell by just doing a little quick research about how other states approach it. Is it better to have like the board determine what conditions or amounts that it should be compensated at, as defined by statute? And if we define it as you should consider these factors, including per day, X amount, and allow legislative fiat, meaning when the resolution comes aboard and we vote on it, we could change it or take it off and debate that. Or do you see around the country, it's kind of like whatever the board says is just rubber stamped and appropriated? I think, and I will make sure that I am correct about this, but I think it's done at the legislature. It's not done at a claims advisory board. All right, and the second thing I'm worried on, now let's get on the topic of what type of cases, and I know you say you only handle DNA exonerations. I think that's a no-brainer. I think it's a little bit tougher when you start getting outside of that. You have people who are people who are not charged with rape crimes, but eyewitness testimony, we see that in murder cases, and perhaps because of racial animus, and you see that a lot in the South. Then the question then becomes, and the vehicle which they get the case in front of a judge is to say that I received ineffective assistance of counsel because of the habeas and the federal 2255 statute. The only thing that exempts you from the statute of limitations is that allegation. And Madam Chairwoman and I had a long discussion about this in the last resolution that we voted on, that because I think some members of the committee and some members of the legislature view that absent a prosecutorial misconduct or some wrongdoing by the state, that we're not sure whether or not that is an area where taxpayer money should be given, right? And I'm just framing the issue here. I think that's a policy debate that we probably need to have. The other standard is, if you accept the fact that an ineffective assistance of counsel as the grounds to hook everybody as wrongful conviction, then you're on the hook for every reversal, which I don't think was the intent of compensating somebody who was wrongfully convicted. How do other states kind of handle that issue of where do you draw the line of which cases are eligible for compensation and which cases are not? I feel very comfortable saying that ineffective assistance of counsel claims don't qualify any. I'm not going to say any state, but in most states, that's a procedural reason for getting out or getting a new trial. It's really cases where an innocent person has gone to prison, and through whatever process there is a record of that person being innocent. Now it's a little difficult because if you like some states try to have a certificate of innocence or a certificate of exoneration. Well, that's a political thing that happens in a county. Maybe the county doesn't want to say, oh yeah, this one's definitely innocent, because they may have liability where a state may not have liability. So that's a difficult situation. Or for a judge to say, yes, you are innocent on the record, that may never happen. But the evidence is there and this person has been released. So what qualifies you as a wrongfully convicted person, it does get a little difficult and a little political, and that's what you all are so good at. But as you said, with our DNA cases, those cases there, it's definitely not the right person, right? And a lot of the times where somebody is exonerated through something other than DNA, the
actual perpetrator is found. And those cases are a lot clearer and a lot easier for you all to deal with.
I think the toughest case is when you have a witness statement recanted. And I think we see that it comes up in the context of death penalty cases. And then we're in a unenvious position of second guessing the trier of fact on many, many levels, and judges on appeals up and down. And so, I mean, those are the kind of guidelines we would like to, I would like to see kind of set in place, saying that, so if you remove it out of the political system in terms of the amount, then we could focus on whether or not what type of cases should get compensated, which may be political. I think the resolution process allows us to do that right now. We can have that debate whether or not someone who received an effective assistance because of recanted confession, we could have a policy debate about whether or not this person should be compensated. But I would like to see a clear guideline on, and if you know any other states will figure this out as to these cases qualify. And the question becomes, who should make that determination in the first place? Is that the board, or is that something you want to take a risk with in the General Assembly, which I think would be much more difficult? Or if a judge or someone who granting the writ makes a finding that this person is innocent or there was insufficient evidence or something that we could kind of, the legal standard we could hang our hats on, so that we don't have inconsistent application, because the formula we could figure out, but the application of who gets it is another issue that might come up in terms of, whether or not this person is compensated or not.
Yes, and that would change how many of these you will see, if that's not reasonably tight. But let me just say, if somebody actually gets out for a recantation, you might want to think that they might actually be innocent, because that's a hard thing to do. So yeah, I mean, I think on its face, the cases are going to be clear. But I've written that down. I'm going to find out what the standards other states have been using.
One more, just a logistical thing. A couple things. Once this resolution passes, is the expungement of the record automatic?
No, it is not.
Okay. That's something we need to look at.
Yes.
What about things like Social Security? So if they're under 65 and they've been incarcerated for a long time, they don't qualify for Social Security.
No, they don't.
Mm-hmm.
So is that something that we need to talk to the feds about?
That would be excellent if you could, yeah.
And part of it, that, which required the compensation, we need to direct them to withhold payroll to pay the Social Security Trust Fund. So
yes.
Logistically, I'm thinking about, okay, well, if you do this formula, and when they hit 65 and the 20-year annuity runs out, right?
Right.
We want to make sure that they're eligible for Medicare and Social Security, so that we have some kind of a safety net, that they're back into the regular system instead of being on the, relying on the government's, state government's kind of foresight from the time that they awarded generosity to keep them self-sufficient as much as possible.
Yes, because I mean, for instance, they also can't get disability because they don't have SSI, and so that becomes a problem. Yes. Yeah. And also, there needs to be a way that this is. It would be great if there was a way that this was not taxable, state or federal.
Well, state, it's not taxable, but federal government wants their money.
Yes.
And that's what we found with this last resolution, and trying to help him determine what he is to do. And that's going to be a burden for them, because they're not used to paying those kind of taxes.
You may be able to get around that by awarding it as pain and suffering.
Exactly.
Right.
Instead of compensation, then, which is taxable.
Right. Yeah. It has to be. There has to be.
But I didn't give any advice by evading federal tax.
Yeah, but it's very difficult.
But that is very true, because the resolution does not speak to pain and suffering. It's a compensation resolution. That is why it's taxable. So you're absolutely right. That based on what the CPAs have told me, that's why it's taxable. I have a couple questions, and I'll get back to you, Mr. Allison. When the judge issues an order overturning a case, why don't they expunge the record at that time?
I don't know. I don't know what the process is different. It involves, I don't know why. I mean, I guess it could be done in court that day, but it's not a part of the actual process.
Well, in Mr. Ward's case, it took him over a year to get his record expunged. He had to apply 3 times for his record to be expunged, and in the meantime, you can't find a job because, you know,
You need that record expunged.
you need that record expunged. And so that's something that we really need to work on, because that is an impediment that we should be able to fix. The other question I had, I looked at what some of the other states are doing, and this whole question about if the person pled guilty, that's a consideration. Would you speak to that?
It is in some of the other states' statutes. And I understand the thought is that you've pled guilty, therefore you're admitting guilt, but you weren't guilty. What you need, I mean, you all know, the criminal justice system would shut down but for guilty pleas. Mm-hmm. So there is a real push to get people to plead guilty. There's incentive. You get a lesser sentence. You know, in one of our cases, he did plead guilty. And he pled guilty because he had a hearing, a suppression hearing on the eyewitness identification. The judge says, this is the worst eyewitness identification I've ever seen, but I'm going to let the jury hear it. Well, once that information goes to the jury, you know, there's a real chance of him being convicted. So he took the plea and got a very good deal. He got 10 to serve 4 on that case. So there's a reason they plead guilty, and I think it's being dishonest when you look at the criminal justice system to say that innocent people wouldn't plead guilty.
Okay, Mr. Allison.
Well, I was going to ask a different question, but I'll fundamentally agree with you there. You know, having practiced in the criminal area at least for 10 years of the 17 that I've been practicing, I can't tell you how many Alford pleas I've done with folks who will not admit their guilt, but will take a deal because they know that a jury could possibly convict. What I want to follow up with you about, my last question, I really promise this time. You had mentioned that Texas drafts some kind of either, do they do a scholarship or do they just agree to hands down pay for the technical training? Because some of these people, like you said, get out with very little skills. I would like to know how Texas handles that, because that is in addition to any compensation, first and foremost, correct?
Yes.
And how do they do that? Because that's intriguing.
I don't know, but I'm going to find out.
Oh, well, I appreciate that. Thank you.
And I will say that, you know, they offer them as health insurance as state employees. When Clarence went through, Clarence had liver cancer in prison. And so one of the legislators in the Senate just got all excited about that and wanted to get him on the state health insurance. And because of HIPAA and, you know, Lord knows there are all kinds of rules about that. It was too late in the process to figure that out. But I think that, you know, obviously Texas figured it out. So I think that one is also possible. I want to go back to the whole how much money it really takes. Our first 2 exonerees, I browbeat an economist in California who does personal injury cases to actually volunteer with me and do a full, you know, how much your life is worth evaluation. In both cases, it was well over $3 million of actual financial loss to these people while they were in prison. Now, that included the fact that they weren't paying into Social Security and everything, but the economists looked at what their job was when they went into prison and what their life expectancy was and their health and everything, and came up with these astronomical figures. So actually trying to you know, figure out what a life is worth is complicated, and the number will end up being very high. And I think that's why most states have just kind of gone with a per year, you know, minimum per year, because individually I can't imagine how much that economist cost personal injury lawyers. We were fortunate to have him for free.
Okay, any other questions for Ms. Maxwell? Thank you so much. We appreciate you, and we appreciate what the Innocence Project has done in our state.
Okay.
And you're going to get us the answers to those questions?
Get you some answers, yes.
Okay.
Thank you.
Very good, very good. Is there anybody else who's here who would like to share anything with our committee this morning? Come on up.
May I be heard, Madam Chairman?
Yes, please.
Good morning, Madam Chairman and distinguished representatives. My name is Todd Ashley. I'm the Deputy Director of the Prosecuting Attorneys Council of Georgia. And I asked to be heard today simply to offer the Prosecuting Attorneys Council as a resource to this body. This is an issue that is important to all of us in this system. It is a prosecutor's worst nightmare to get a notification that you tried the case or took the plea that put the wrong guy in jail for 28 years. I have been a prosecutor for 15 years, 2 years as an assistant solicitor in Cobb, 12 years as an ADA in Fulton County, and I've been with Prosecuting Attorneys Council for 1 year. And my experience is pretty broad. And on behalf of our Executive Director, Chuck Spahas, and our council, to the extent that we possess experience and knowledge and background to help this committee on this issue, we're here to serve. May I recognize some folks?
Sure.
Ma'am. Also here with me today are Ms. Laura Murphy. Ms. Murphy is the director of our capital litigation project. Working with Ms. Murphy is attorney Jenna Fowler, who is with the Prosecuting Attorneys Council also. Ms. Murphy and Ms. Fowler, in partnership with the Innocence Project and the GBI in 2013, sought and received a federal grant north of $400,000 to study untested forensic evidence in the vaults of law enforcement agencies in Georgia. That was an effort that was essentially initiated by the prosecutors. And our relationship with Ms. Maxwell and Ms. Cribbs also, I'll recognize Ms. Cribbs from the Innocence Project, is one that's important to us and one that we take very seriously, and are happy to work with them on that. And the GBI as well, Director Keenan and all the staff at the GBI have been terrific partners in this effort. It gives me great relief to hear that of the 8 Georgia exonerations, none of them were due to prosecutorial misconduct. That was a tremendous relief moment. And so to the extent that, that we can provide expertise, background, or any help at all to this committee, we're here to serve.
Well, we're very pleased that you all are here and willing to do that. And my focus is on the fact that we do have a good judicial system here in Georgia, but anything that man creates is going to be imperfect. And when things happen, we should recognize that and have a process to take care of those instances. So we want to work with you all, and we want to hear from you in terms of what you would suggest that we do and how you all think we should proceed in handling the few instances, because I don't anticipate we're going to have a lot of these cases, but when they do come up, hopefully the next time one comes up, none of us will be in the General Assembly. It'll be that long.
Well, they're tremendously unfortunate, and they give everyone who cares about justice in the Constitution concern. Mm-hmm. And nobody recognizes the fallibility of certain evidentiary matters more than prosecutors, because we, you know, as the originating and presenting member of the criminal justice system, you know, we see it a lot. And to the extent that we can be part of the solution, that's what we want to be. May I approach the chair? Ms. Murphy has prepared a table of the state's compensation laws as well as the state's DNA access law. This may be of some benefit
Sure.
to the committee if I might approach.
Thank you. And I'm going to ask you a question. I want you to answer a question that one of our committee members.
I don't know anything. I just work.
In terms, if you all could help us with the type of cases that we should be considering, don't you all think they should be able to help us with that?
I think Representative Pack made an excellent point. The no-brainer types, when DNA is involved, and clearly points to a different perpetrator than the person who is incarcerated. Probably, you know, and keep in mind, my executive director and my counsel would probably want to issue a policy statement on that. So against that slow boat, let me say that I think the DNA cases would probably be the focus of this body and the things that we would concentrate most on, because quite frankly they're the ones that lend themselves to the easiest and most just resolutions. When you start expanding post-conviction litigation into eyewitness identification or recanted testimony, particularly when there's no malfeasance on the part of any state actors, and I would note that even in these cases it was the investigating detectives who secured the DNA evidence and the investigating agencies who preserved it that made it possible for these exonerations to occur. And so there being no bad actors on the part of law enforcement or the prosecution team or in the courts, when you get into extracurricular evidentiary matters like eyewitness identification and recantations and false confessions, those become more problematic for everyone involved in the system.
Okay. I see number 24 wants to have a question.
I appreciate you coming today.
Yes, sir.
Just for the committee's knowledge, when did DNA become basically used in rape cases for most prosecutors? Secondly, I take it now with every prosecution you make that you have a rape kit, you are at least getting a DNA sample from the defendant. Is that not correct?
I can't speak to that, but I can find out and respond.
Okay. My concern is Representative Mayo asked a very relevant question of how many more of these can we expect. So I would hope in the last 15, 20 years that most of the convictions that would have had DNA evidence would have matched against a defendant, correct?
Yeah.
I would hope.
I'm sorry. Could you restate the
Sure.
question?
Several of these folks, for instance, Mr. White, 28 years, DNA wasn't around when he was convicted. But what Mr. Mayo's question was earlier to Ms. Maxwell was how many more of these can we expect? And my guess is that with advancement in DNA testing and with a lot of convictions now being associated one-on-one with a DNA profile, we shouldn't see many more from this point going forward, should we?
I would welcome the participation of Ms. Maxwell in responding to the representative on that. But I think I would agree with you. I wouldn't expect a whole lot more. To the first question, when did we start using DNA? The advances in DNA or its acceptability
right.
Probably came up during the mid-'70s, if not before, in the '90s. Well, the technology was around and it began to be investigated at least before the '90s. But the technology in DNA has gotten better as the scientists have been able to more specifically identify the markers specific to each one of us as human beings. Those advances, I believe in at least one of our cases, one of the individuals was convicted using DNA, but the advances in the DNA science led to his exoneration. Am I wrong, Ms. Maxwell? That's not a Georgia case? Okay. Okay, right. Then, so it's been around for a while, and to the extent that testable samples still exist, that's why we got this money, and that's what we're doing.
Thank you.
Yes, sir.
Mr. Pack.
Thank you, Madam Chair. What is kind of the process or the standard that someone has to meet to reopen a case that's already past time, to challenge or to be able to show actual innocence?
Ms. Maxwell?
You have to show that the identity of the perpetrator is a significant issue, and you have to show that there's a reasonable probability of different outcomes.
Okay.
So it's a pretty high standard.
And do you have a time period in which you have to do that?
So we started using it here in this country in about the 90s in police work. And as far as all those cases, when our staff attorney, Ms. Krebs, was an intern, she was the intern that exonerated Michael Marshall, and he had only been in prison for 2 years. So they had DNA, they just didn't do anything with it. So I don't think that's going to come up that often, but unfortunately it does.
What about cases in which DNA is inconclusive?
In those cases, then I think the judgment would stand.
So it can't just be that. I think some of the other statutes says if it's proven by DNA. Maybe I'm thinking too much in the minutia, but I could see a situation that my preference is not to just limit it to DNA, because I do think that there will be some cases that fall through the cracks. I think some of the states drew the line at DNA. I want to have some mechanism to be able to, review that, in the sense that maybe the legislature will follow the normal process now, or something like that, like a catch-all. But I'm not quite sure what number that they would be going forward, and whether or not it's worth it in terms of the exercise to think about those things.
Are you saying that you would rather see it opened up to the eyewitness claims and the recantations and confessions? And
Right. I know and I know what you're saying. It might be a slippery slope. It might be a little dangerous, but it seems to me that's something that's worthy of looking at. We try to get it as close as possible. By just saying only DNA cases, yes, I think that's a pretty far. We'll probably capture a lot of them, because you could show actual innocence, or at least meet the burden of reasonable probability of a different result. But I think there are cases when you don't have DNA because they didn't collect it at the time of the real perpetrator. And I'm not quite sure. I mean, I know people say when we're in the legislature, don't let the perfect be the enemy of the good. We're talking about somebody's life, I think we should try to get it as perfect as possible. And if you have any opinion on that.
I would say that the trial process tests that. The trier of fact, it's not a matter that's undertaken lightly. And as the guy that tried J. Broderick Brose, the defendant's name, the second time in Fulton County, and that's the case that got reversed that led to removing the level of certainty language from the pattern jury charge on that case. In those cases, and we're certainly sensitive to what the representative is saying, given his experience.
Well, let me give you a scenario I'm thinking
Yes, sir.
about here. And let's remove DNA. You have a state statute that we pass in our wisdom, think it's a good statute. And then later on, in a constitutional matter, at a U.S. Supreme Court strikes it as unconstitutional, meaning it can't be a crime or whatever it is. Then the question becomes, then you open up the habeas from that point on, and then they say, look, I wasn't guilty of a crime, as a legal matter, not a factual matter. Should we exclude those folks from compensation?
I think that we would open up a new realm of post-conviction litigation that would
I think you're going to get that anyhow. When you have a
available
U.S. Supreme Court
resources.
rule coming down, you're going to get your habeas, right? You agree with me? So we're past that.
For the sake of this
Right.
exercise,
We're,
yes,
we're
sir.
past that. I'm just thinking, okay, well, all right, well, this person wasn't guilty as a matter of law from the beginning, right? Because Constitution generally doesn't change. Then the question becomes, should they be excluded from the compensation statute that we're seeking because of the fact they didn't involve DNA?
That, probably in all likelihood, is a legislative matter left to the wisdom of this body.
Okay.
Just for the record, currently, it's just a matter of the person presenting a claim against the state. There are no parameters, am I right, Jill, in terms of what kind of case it has to be? They have to present a claim against the state. We don't have any parameters right now. So what we're trying to do is set some parameters. So when you say you'll open it up, it's already open. It's whatever the legislature would entertain. I just want you to remember that.
remember that. I'm just trying to. I guess my point is, as we think about this issue, the easy way is to say actual innocence or proven by DNA. But if we adopt that kind of standard or give the standard or guidelines to the board reviewing it, I think we're making it too narrow.
Right.
That's why the example came about. And if you're saying that the prosecuting attorney's counsel is not going to take a position on that, then I guess we need to figure out legislatively what to do with it. But if there is some consensus or other states have kind of looked at this issue and they say, yeah, we're going to count them, then we would like to know that.
Sure. And perhaps at the next meeting, we'll be prepared to respond further.
Thank you.
Okay.
Yes, sir.
Jill, did you want to weigh in?
Yeah, just as a potential for you all to consider in terms of your hearings and such, you might want to consider getting somebody in from the Claims Advisory Board to talk about the process. And that might answer some of these questions that you're having about how it works and like how wide the range is. Of course, nobody can predict the future, but the past is somewhat of a good idea to look at. I know all of these folks that are on the resolutions have gone before them, but you don't know, and I don't know what you haven't heard about.
Right. Well, we did invite them today. They were just not available to be with us, and hopefully next time they'll be able to be here. Any other questions for? We thank you so much for being here, and we thank you for your willingness to participate. We invited the prosecuting attorneys, and we also invited the courts because, everybody who is involved with this, we wanted to hear from and touch base with and that kind of thing. So we thank you so much, and we look forward to hearing more from you in the future.
Thank you, ma'am. May I be seated, Your Honor?
You have my permission.
Thank you.
Now, for our committee members, do you all have any other concerns or any other research requests so that we can put them out there and then we'll talk about our next meeting? Anything else you want them to look at? So what they're going to look at is looking at what other states do. We're going to look at something related to the types of cases that we should be concerned with. We're going to look at some parameter in determining amounts that should be considered. That's what I've heard so far. Have I missed anything? Okay, and we'll try and get the Secretary of State's office, who is the lead agency on the Claims Advisory Board, to send somebody next time. They were not available this time, and we're going to hear from the Innocence Project on some specific things that we've asked them to do. Now, in terms of our next meeting, because we're trying to do it in 3, so the next meeting is going to have to really be a work session for us. I'm looking at September 16th, 17th, or 18th. Are any of those dates good for you all? Good.
I can't do the 18th.
Okay. Mr. Allison?
I'm good on the 16th or 17th.
16th is good. It's best.
16th. Okay. Well, 16th then. We'll make it the 16th. Is that okay with everyone? So September 16th is our next meeting. And for October, if you would look at your calendars for any time during the week of the 13th of October, to see how that looks, and we can make a decision on that between now and the next time. Is there anybody else that has anything that needs to come before us today? I failed to introduce to you all Robert Seals, who's sitting down there, and he's with our office, and he's going to help us do some of the research as well. So Robert has been taking notes, and so he's gonna help with that as well. So again, we thank everybody for being here, and we will be back on Tuesday, the 16th of September, with some answers and more questions as we move forward. Thank you so much, and we're adjourned.